consulting.
That he's a consulting expert.
Okay, a little bit more detail. Is he a witness or consulting expert? Or rather an expert, sorry, I won't use the word consulting.
He's a non-testifying expert, is what they classify him as. Under they call it the latter category of 26B4D.
Yes, great job, great job. So the court says, in one sense, we're acknowledging Mr. Weiner is not a witness. He is an expert, in which you define what type. And the reason they said he's an expert, he's a maritime engineer, and he's specifically engaged or hired by Chiquita to examine the vessel in connection with the cargo loss claim. He's clearly an expert. He brought his technical background to bear in observing the condition of the gear. And the court said he does not forfeit his status, and now all of a sudden he's a witness merely because he made a personal examination of the vessel and therefore learned facts rather than simply offering an opinion based on the observations of others. And so in terms of the court's holding and reasoning, they said the international reefer nevertheless contends that the discovery should be permitted under exceptional circumstances, clause of the rule. And the court says, this argument would have merit if international reefer had been precluded from sending their own expert to the scene by forces beyond its control. And they said, but that's not the case. They said the plaintiff didn't bar the defendant from examining the vessel after it docked. They could have done their due diligence and sent their own surveyor out that. So they said, the court said, under these circumstances, international reefer's failure to engage its own marine surveyor in a, quote, timely manner should not be rewarded by permitting discovery of Chiquita's expert. To do so, they said, would permit the exceptional circumstances to, in a sense, swallow or undermine the whole purpose and spirit of having Rule 26B4. One of my attorneys, how does the court address the defendant's argument that even if it's foreclosed from deposing Mr. Winter, it should be given access to his file? How does the court address that argument? How does the court? Either attorney Bacchus or Lawson.
It says that Rule 26B4D applies to document discovery as well as depositions.
Great. And read some more.
International Reefer is correct that information does not become exempt from discovery merely because it is conveyed to a non-testifying expert. Thus, while the file may contain Mr. Weiner's recorded observations and opinions which need not be disclosed, it may also include discoverable information provided to Mr. Weiner by others.
Perfect. All right. So court says the defendant can't depose the expert, but the court does require that Chiquita produce only certain portions of the expert's file, meaning the expert doesn't have to produce the portions of his file that are his opinions or his fact observations, but he should disclose discoverable information provided to him by others that perhaps may have been on the scene. So let's just take a moment and compare the Chiquita and the Thompson cases, because I think they're worthy of doing a comparison analysis. So these cases are in your text essentially to show you that beyond relevance and privilege lie the discovery protections that are granted to non-testifying experts. How do you distinguish the Thompson and Chiquita cases? Meaning, I guess my first question would be, what were the exceptional circumstances in both cases that led the defendant to argue that they should have access to consulting witnesses?
In the Thompson case, there was no other way for them to get the information besides the file from the psychiatrist. Whereas basically in the Chiquita case, they were saying you could have sent someone and you didn't, so it's on you.
Excellent, excellent. Since you're on a roll, one more question. Why did the defendant get all the information in Thompson but not in Chiquita?
Because it was a medical file.
Okay. Any other reason? And if not, co-counsel, because you're doing great.
Did that first exception apply of the medical professional?
Which is what she was referencing, yes. And what are your thoughts over here? Why did the defendant get all the information in Thompson but not in Chiquita? I can't hear you.
I said I don't really know.
Okay, that's fair. Honest. All right, so in Thompson, the defendant got all the information, presumably because it was highly relevant, as you might recall, and impossible to duplicate, even if the defendant had sought to do it. Like, they only had that small window, that 10 days after the firing to capture the plaintiff's state of mind during that time frame. So again, it was highly relevant and impossible to duplicate. In Chiquita, the defendant didn't get the information because the defendant knew of the likely claim. They had control over the vessel and they had the resources to investigate. So they had other means of getting to that information. They just didn't do it. They didn't do their due diligence. So you can see the distinction why the court is saying that's not exceptional circumstances. You should have done your due diligence and had a marine surveyor out there to meet the cargo ship when it applied. But the mental state, you can't kind of rewind and go back to what someone's mental state was after being allegedly sexually harassed and fired. You just had that small window of opportunity. So that's why that qualified for exceptional circumstances. So everybody understands these two cases. They're cool. Just remember, we started out with boring Penoyer. Like, we've come a long way from Penoyer. All right. Penoyer was bad. Okay, so let's end with our discussion of discovery and protective orders. So we've mentioned kind of casually protective orders, but I need to discuss them in a little bit more detail to make sure you understand it. So in addition to time-consuming and expensive, one of the issues with discovery is that it can also obviously intrude on people's privacy, depending on what you're asking for. The federal rules handle this issue by allowing parties to seek protective orders when they deem fit. And so Rule 26C1, which is not up there, and I apologize, permits a judge to enter a protective order, again, that's 26C1, to shield a party or non-party from annoyance, embarrassment, oppression, or undue burden or expense. So again, Rule 26C1 permits a judge to enter a protective order to shield a party or a non-party from annoyance, embarrassment, oppression, or undue burden or expense. Last time, Rule 26.1 permits a judge to enter a protective order to shield a party or non-party from annoyance, embarrassment, oppression, or undue burden or expense. So the rule permits the party seeking protection essentially to make a motion for a protective order. The party that's seeking the protective order has to certify to the judge that he or she has in good faith tried to confer with the other party to not have to resolve the dispute about the information they're requesting before they get the court involved. Rule 26C1 then goes on to tell you different things that a judge may do when they're issuing the protective order. The list is not exhaustive, so for example, a judge may forbid the disclosure of discovery item, or for instance, they can allow some, as we saw in the Chiquita case, but not all of the discovery requested item to be given. So there's different examples they give you of what the judge's options are. I encourage you to take a look at that on your own because you do need to know that for practice purposes, kind of what the possible outcomes are. And again, that's Rule 26C1 has that information. Rule 37 that actually is behind me talks about sanctions. So if you put an order for a protective order, the judge says no, you still have to give the information. If you refuse, there are sanctions under Rule 37, i.e. punishments that you might be given for not following a discovery request. So Rule 37 sets out the various means by which rules of discovery may be enforced. So it's a very important rule. So again, if the party fails to respond to a discovery request, the opposing party may file a motion requesting that the court compel discovery. If the court grants the motion, essentially, and they refuse, they're then subject to sanctions. So for this class, we're mostly going to focus on Rule 37A, B, and D, like dairy, just A, B, and D. But I want you to know that won't be on the exam. I just want you to know for practice purposes, there are additional rules that govern discovery. Specifically, you can have sanctions issued for failure to participate in like a Rule 26F conference. If you don't show up and like whatever, you can have a sanction for that, and that's Rule 37F. Failure to satisfy your duty to supplement discovery materials, failure to give mandatory required disclosures. So there's a lot of them that are listed, but I just want to let you know that it's pretty broad. So a court order to compel discovery may be directed towards, again, any party that fails to answer a question. I do want to note that I'm not going to do that one. So what do you need to show to make this motion to compel discovery? If you take a look at Rule 37A1, 37A1 tells you what you need to do in order to make a motion to compel discovery. And so I'm going to read exactly what the rule says verbatim. It says, on notice to other parties and all affected persons, a party may move for an order compelling disclosure or discovery. The motion must include a certification that the movant has in good faith conferred or attempted to confer with the person or party failing to make disclosure or discovery in an effort to obtain it without court action. That is verbatim from the rule. If you didn't get to write it down, if you Google 37A1, it comes up. You can copy and paste the text, put it in your notes. All right, so basically what this means is that the rule requires the moving party, as it sounds, to certify to the court that they've tried in good faith to get the information without court involvement. In briefing and arguing the motion, the responding party may try to convince the judge that the material is privileged or otherwise protected from discovery. If the court indeed grants the motion to compel discovery or to answer such questions, the other party may be able to get their attorney's fees paid for the time they spent compelling the motion to just having to go through the motion, meaning the reason the court will sometimes say you're going to have to pay the other party's attorney fees is they're like, this was obvious. You knew that you had to give this information. You're trying to unduly delay or harass the other party, and now you're going to pay their attorney fees. Don't waste the court's time. So know that you can be forced, not always, but if it looks like it was pretty obvious and egregious that this was not a real discovery issue, the court will have you pay the other side's attorney fees. So what then happens if you get the court to compel disclosure and the party doesn't comply with the court order? There's a list of things I have behind me here. Rule 37B2A. These are just options. Dismissing the action or proceeding whole and part, rendering a default judgment. I mean, it can get pretty ugly depending on how much of a jerk you're being. The last thing you want is a default judgment in the other party's favor, because how do you explain that to your client? That's very, very bad. So just know that this rule, this section lists the different options that the court has. So the rule's basically telling you, again, the number of things the court can do if you fail to follow a discovery request. In most instances, sanctions are imposed by the court after a party, again, is just being reluctant. I want to talk about some common good, meaning why do we even have these sanctions, right? Why do we have this Rule 37 behind me? And so if you think about it, Rule 37 serves a really important part in our justice system because if you had no sanctions available, just imagine, like if there was no way to enforce or compel someone to give information over that you need to build your case, it would undermine the whole purpose of our system, which is, remember that very first class we did the Hunger Games, and we talked about the different reasons that we even have the rules for transparency, the idea that the more information, access you have to information, the big picture will ferret out the truth. You know, the cream will rise to the top. And so, if we didn't have these rules, you'd have a lot of parties failing to comply with orders to compel. You'd have parties using the discovery process to abuse or harass other people. It would be very problematic. So Rule 37 is very important because it creates stability, right, in our justice system by providing some type of checks and balances against abuses of discovery and abuses of our pleadings rules. So these sanctions are very, very important. Let's cover our last case, which is the Zubalake case. Zubalake versus UBS, kind of an older case now. So what was the underlying suit about in Zubalake? Ugh.
She got passed over for a promotion, and the guy that got promoted above her started harassing her, so she sued the company for gender discrimination, failure to promote, and retaliation.
Excellent. Do you mind telling us what the discovery issue is? What are they all heated up about?
About the backup files and electronic files of emails and documents that were sent around.
Excellent. So, interesting case. So we know that the plaintiff's underlying suit is she's claiming gender discrimination, right? And they're in the discovery phase of the lawsuit, and she sought a number of digital records that she feels like she needs for her claims. As he stated, especially important to her in those records are emails between her supervisors and others that are referencing her in their emails. And the problem arose because in spite of an internal order to preserve those records, UBS's IT team wrote over the backup tape. So the company said, look, we have a potential lawsuit, preserve these records, IT's allegedly screwed up, right? There's no claim of intentional destruction. Apparently the people in charge of IT simply got the wrong message. But the tapes were nevertheless destroyed. This is a big deal. So imagine you have a gender discrimination claim, and the emails of people talking smack about you, saying no woman should be in this position. You know, she's gonna be calling all the time to go pick her kids up from school because they're sick. Like, all your evidence is destroyed. Like, wouldn't you be devastated? You have a legitimate case, like your mom is being screwed at her job, she files a lawsuit, and then the evidence is destroyed. I'd be like so upset about this, right? So why did the plaintiff originally want the emails? Well, she claimed that the evidence, she needed the evidence, right? She needed the evidence to prove her case. And the email correspondence, again, amongst various UBS employees was stored only on the UBS computer system. So that's like U of L. We have our Outlook system that has correspondence, you know, between myself and employees in here in the law school. And then all of a sudden those emails are, it's bad, right? So either of my other two attorneys, what is the plaintiff seeking now after the emails were destroyed? She basically wants three things.
Well, one of those things is an adverse influence instruction.
Okay. Yes, yes, and yes.
Which is, I guess, that it's an evidentiary influence. It goes against, I guess, the party's interest, the UBS's interest at trial, which I guess the jury is able to infer that the spoliated or suppressed or deleted evidence is relevant to her claim.
Yeah, so that's a great request she's asking for. She's like, look, I want an adverse inference at trial. Like, I want the jury to know that the evidence that I needed to prove my case was destroyed. I want them to know, you know, that basically UBS might be being a little dishonest here, and even if they're not, you know, they took a large part of my case. That's going to look bad on the company because the jury's going to assume they probably did it on purpose, right? So, yeah, she wants an adverse inference instruction against UBS with respect to the backup tapes that are missing. What's another thing she wants?
She wants sanctions for the defendant for failing to provide relevant information and for tardy production of said information.
Yes, yes. Anything else on the left? Anything else? She want them to cover anything for the trouble?
Yeah, she wants them to cover the costs of reproduction
Fabulous job. Yes. Okay, so she wants 3 things. So she says, look, I want an order requiring UBS to pay in full the cost of restoring the remainder of the monthly backup tapes. They should carry the burden, and they need to get those tapes. 2, she wants an adverse inference instruction for the jury against UBS with respect to the backup tapes that were destroyed. And then 3rd, she wants an order directing UBS to bear the cost of redeposing certain individuals, so do a deposition over again, such as Chapin, concerning the issues raised in the newly produced emails. So she wants those 3 things, and I think she should be asking for them. When can you be sanctioned for destroying evidence? A party can only be sanctioned for destroying evidence if you had a duty to preserve it. So if UBS had no such duty, then obviously UBS can't be faulted, meaning for the spoliation of evidence. When does the duty arise? Because that's important. So, because I want to know when it arises so I can look at my client's facts and say, no, they had a duty to preserve this evidence. They're going to get sanctioned. And hopefully we're going to get a default judgment because they did this on purpose. They were trying to screw us over. Well, the obligation to preserve evidence arises when the party has notice that the evidence is relevant to the litigation, or when a party should have known that the evidence may be relevant for future litigation. So I'm going to say that again because it's important for you to know when you can file this Rule 37, because somebody has tried to get rid of information that they know you need it for your case. So the duty to preserve evidence arises when the party has notice that the evidence is relevant to the litigation. So 1, when the party has noticed that the evidence is relevant to the litigation. Or 2, when a party should have known. Okay, you knew this claim was already filed, that they already filed an EEOC claim. You knew it was highly probable they were going to file a federal claim after they exhausted their administrative remedies. You knew you shouldn't have destroyed that information. So the second is when a party should have known that the evidence may be relevant to future litigation. If somebody has filed a complaint, they're on notice, even if it's an internal complaint. If they're trying to exhaust their administrative remedies, as we saw in the Prison Litigation Act case, then you've been put on notice. And that's so good that this is in place, because before this rule, remember, we started with Civil Procedure Rule number 1. So before Rule 37 was added to our, they didn't just add them all at one time. People were just, oh, sorry, we don't have that, we only keep our records for, up to 2 weeks at a time. Sorry. Like, people were getting totally screwed, So this is great. I got your email. Thank you. I'm surprised you still came. All right, so now if we apply that rule to the facts, meaning with those 2 exceptions, according to the court, when did the duty to preserve evidence arise in this case? Because that's what we care about. When did the duty? Yes, thank you.
April 2001.
Okay, when Zubalake did what?
So she got her EEOC
Yes.
paper, and so they were put on notice.
Yeah, so she filed an EEOC charge, again, exhausting her administrative remedies. So they were on notice April 16, 2001. And at that time, UBS's in-house attorneys cautioned employers to retain all documents, including emails and backup tapes, that could potentially be relevant to the litigation. If at some point you're in-house counsel, that is one of your responsibilities. When you're put on notice that someone has filed an EEOC claim against your employer, you need to tell them. We don't want to be in a Rule 37 situation where we automatically could lose the case on a default judgment because we did spoliation of evidence. We didn't keep evidence we needed. And so, that's very important. So the attorney did their job. They said, keep these tapes. I've just been notified of an EEOC claim. And so in the meetings with Chapin, Clark, Kim, Hardesty, John Holland, and Dominic, who was Zubalake's former supervisor, UBS is again outside counsel, reiterated again the need to preserve these documents. So merely because 1 or 2 employees contemplate the possibility that a fellow employee may sue does not generally impose a firm duty to preserve, but in this case, almost everyone associated with Zubalake recognized the possibility that she might sue. So it's not like this random conversation between employees like she filed a claim, that's more than enough notice. So the relevant people at UBS, anticipated that the plaintiff might sue in April 2001, and that's when that duty attached. So what does the court say is the scope of the duty to preserve? What exactly do you have to preserve or keep? What's the scope of that? For instance, must the corporation, upon recognition of the possibility of future litigation, preserve every shred of paper, every email or electronic document, every backup tape? Like, what's the scope? Are you serious?
What?
Go ahead.
Well, they have to make a litigation hold at the outset of litigation, or whenever it's reasonably anticipated. Then they have to communicate directly with key players in the litigation, such as people identified in the party's initial disclosure and any subsequent supplementation thereto. And then they also have to instruct all employees to produce electronic copies of their relevant active files. And they have to keep doing this on an ongoing basis to make sure that, anyone who, to remind people. They also have to talk to IT and be familiar with the saving processes.
Mm-hmm. All right. Was that supposed to earn you an attendance for the day?
Nope, I was just showing off.
Who says that? Like,
You say that. What do you mean?
What if I said, don't you don't people want to be you never, even if you are cocky, you never want to come off. You want to be the person that's cool, even though inside you're I got this, but you don't say it.
You literally say it.
When?
You say I'm just showing off to show off.
Okay, show of hands. When have you heard me the entire semester say I'm just showing off?
You say that. You said, or I would
Thank
have said
you.
that to
Thank
show
you.
off.
Yes.
You said
People are
it a
scared to
couple
vote.
No, he
Right.
didn't.
See? This is oppression.
People are scared to
This
vote.
is oppression. See?
It's not a person. You guys are a number. I don't even know who your exam is. You're a number. You are. You're a number. Okay. Not to devalue your worth, but you are a number. All right. So we know that a corporation doesn't have to, obviously that would be crippling to a corporation to have to preserve every shred of paper, email, electronic document, or backup tape. At the same time, though, anyone who anticipates being a party or is a party to a lawsuit must not destroy unique or relevant evidence that might be useful to an adversary, regardless of the situation. The quote from your case says, quote, while a litigant is under no duty to keep or retain every document in its possession, it is under the duty to preserve what it knows or reasonably should know is relevant in the action or is reasonably calculated to lead to the discovery of admissible evidence. So in order to receive an adverse inference that the evidence which is destroyed was favorable to the plaintiff and not favorable to the defendant, what must the plaintiff prove according to the court to get that adverse action? Thank you.
The party having control over the evidence had an obligation to preserve it at the time it was destroyed. The second one is that the records were destroyed with a culpable state of mind. And the third is that the destroyed evidence was relevant to the party's claims or defense, such that a reasonable trier of fact could find that it would support the claim or defense. And this
Excellent.
all has to be established by the party seeking the instruction.
Rock stars. You guys are doing great, all of you. Thank you. So the court says the first element has already been established, right? Meaning UBS breached its duty to preserve. That's an easy one. So let's discuss the second element, which is culpability, okay? What do you need in order to prove or show a culpable state of mind? Well, the court says you need to show a minimum ordinary negligence. And once you prove ordinary negligence, you still need to show that the evidence was relevant. So again, for that second element, you have to say, look, they were negligent and the information was relevant, okay? But if you can show that the evidence is destroyed in bad faith, that fact alone is sufficient to demonstrate relevance and satisfy all three prongs. So if it's bad faith, the court's like, that's enough. They did it on purpose, and now we're gonna bring down the hammer on them. Okay. So again, if you can show the evidence was destroyed in bad faith, that automatically satisfies both the second and third prong of what she just read. What's the plaintiff's argument regarding the defendant's culpability? Well, we know in this case the plaintiff argues that UBS's spoliation was intentional or at minimum grossly negligent, right? Yet dozens of relevant backup tapes, yet only 6, which is pretty sad, and part of a 7 are missing. That's kind of random. So you've got all these backup tapes and then it just so happens that 6 and part of a 7th are missing. You think those are maybe the ones where they're talking about her gender discrimination? Who says this looks a little iffy? Yeah, I think it's a little shady. The defendant's argument, UBS says, look, the tapes were inadvertently recycled well before the plaintiff requested them, and even before she filed her complaint in February 2002. Well, that might be a strong argument, but if you're getting a supervisor saying, yeah, she's going to be a problem, you got to watch her, she's trigger happy, she's one of those people that's trying to get a big check, then yeah, you're going to go and hurry up and destroy those tapes, or I might have messed up a little bit. And, covering up each other's tracks. So this stuff happens all the time. So what does the court say on the issue when UBS says that the tapes were inadvertently recycled well before the plaintiff requested them? Specifically, what does the court say with respect to whether the plaintiff has indeed proved a culpable state of mind? What does the court say? Is the defendant negligent for some tapes and gross negligent for others? I can hear you. Yeah.
It says that while the litigation hold was sent out, there were certain employees that unquestionably deleted the emails, and although they were recoverable, a number of the backup tapes and emails were lost forever. So counsel failed to communicate the litigation order to hold all key players, and they also failed to ascertain each of the key players' document numbers.
Absolutely. So the court came down pretty hard, and they reminded them in the case, quote, once the duty to preserve attaches, any destructions of documents is at minimum negligent. Okay, so once that duty attaches. And they said, UBS's failure to preserve potentially relevant backup tapes was merely negligent, but not grossly negligent or reckless. So for most of the backup tapes, the court said UBS was merely negligent, but for some of the other backup tapes involving the plaintiff's HR manager, Ms. Tong, in that case, the court says no, they were grossly negligent, mainly because the Tong tapes, as he stated, covered the time period after Zubilake filed her EEOC charge. So it covered the time period after the duty to preserve had attached. And Ms. Tong engaged in correspondence regarding the lawsuit. So they said, in that sense, yes, we consider that to be grossly negligent, if not reckless, in not preserving those backup tapes from Tong. Because UBS was negligent and possibly reckless with respect to the Tong tapes, Zubilake has satisfied her burden with respect to the second prong of that spoliation test. So because the court concludes that UBS's actions were negligent or reckless, then the plaintiff has to prove relevance. What must the plaintiff prove in order to satisfy relevance? Basically, because UBS's spoliation was negligent and possibly reckless, but not willful, Zubilake has to demonstrate that a reasonable trier of fact would find the missing emails would support her claims. Is it likely that those missing emails might support her claim? In order to receive this adverse inference instruction, Zubilake must demonstrate not only that UBS destroyed relevant evidence, as that term is ordinarily understood, but also that the destroyed evidence is likely to have been very favorable to her. Okay, so it doesn't matter if they destroyed evidence that wasn't going to affect her case anyway. And so, in terms of the relevancy element by the plaintiff in this case, meaning was the relevancy element satisfied? Surprisingly, the court said, no, not satisfied. They said the emails contained on UBS's backup tapes were by and large generally relevant in the sense that they bore on the issues of litigation, but in a prior decision by the court on the same case that's not in your book, Zuba Lake 3, the court specifically held that the emails selected by the plaintiff as being the most relevant did not provide any evidence that Chapin's dislike of Zuba Lake was indeed related to her gender. There's no reason to believe that the lost emails then would be any more likely to support her claims. I think that's crap. Let me say that again. The court said the emails selected by plaintiff as being the most relevant did not provide any evidence that Chapin's dislike of Zuba Lake related to her gender. So there's no reason to believe there's any such evidence in the other missing tapes.
That seems to be a logical fallacy, a part to a whole. You're taking certain emails of individuals and then generalizing based on the whole of the emails.
Exactly. I have a problem with this. Yes.
I'm confused because I thought the court said on the last paragraph of 513 that
Yes.
UBS did act willfully, so the lost information is presumed to be relevant.
We're not there yet.
Oh.
But we're getting, I'm talking about the Zuba Lake 3 case, but yes, we're there. And so they said the tape that was most likely, I'll get there, to contain the relevant emails is Tong's August 2001 tape, okay? The tape for the very month that Zuba Lake filed her EEOC charges. But the majority of the emails in the tape are preserved on the September 2001 tape. Thus, there's no reason to believe that any particularly unfavorable evidence resides solely on that missing tape. Accordingly, Zuba Lake was not sufficiently demonstrated that the lost tapes contained relevant information. But let's talk about the court's actual holding in this case. Let's talk about the court's holding. They said the plaintiff does not get the inverse inference, but requires the defendant to bear the plaintiff's costs for redeposing certain witnesses for the purposes of allowing the plaintiff to address issues raised by the destruction of the evidence and any newly discovered emails. In sum, although UBS had a duty to preserve all the backup tapes at issue and destroyed them with the requisite culpability, Zuba Lake cannot demonstrate that the lost evidence would have supported her claims. Under the circumstances, it would be inappropriate to give an inference reference to the jury. Even though an adverse inference instruction is not warranted, there's no question, the court says, that the emails that UBS should have produced to Zuba Lake were destroyed by UBS. That being so, UBS must bear Zuba Lake's cost for redeposing certain witnesses for the limited purpose of inquiring into issues raised by the destruction of evidence and any newly discovered emails. In particular, UBS is ordered to pay the cost of redeposing Chapin, Hardesty, Tong, and Josh Bersano, a human resource employee in charge of they call it equity sales desk, and known to have been in contact with Tong during 2001. The court says for these reasons, forth above, Zuba Lake's motion again for an adverse inference instruction and for the reconsideration of the court's July 24th, 2003 order are denied. Her motion seeking costs for additional depositions is granted. Attorney Mwanga, do you feel this is a fair case? Do you feel like they should have had to pay the cost to redepose the witnesses?
The defendants.
The defendants?
Yeah.
Really?
Yep. Because
They said they didn't do it on purpose.
they're lying.
Who says they shouldn't have to do that? Okay.
I'll make
You like it too?
it. Yeah.
Why does it keep doing that? I mean, this alarm keeps going off, and I have no idea why. Why do you feel, and it's so funny, Ryan, it's for you, that's what's so funny.
For the.
Yeah, that's what's
yeah,
so
I was
funny.
gonna talk to you
Yeah,
about that.
but it's like, keeps going off, reminding me, 2 hours before. Yes,
Just because it seems like they should have the burden to preserve it, and if they didn't, then let them foot the bill.
let them foot the bill. All right, yes, what do you think?
I mean, they chose their own process of how they were going to retain the information. They should have anticipated that they might need to retain it.
I've run out of time, and say,
Yeah.
you know, yeah, you should be on notice when the EEOC thing is filed, but isn't that a lot to keep up with? When you're gonna think about these mega Microsoft, Apple, these corporations, maintaining all these backup files. Jessica?
The only time I would make an exception is if there was something that was beyond their control, like if they could prove that maybe there was some sort of a virus that attacked the server and caused it to wipe out. But in this case, it was those they were destroyed through negligence, so I can't really make a difference.
If and I'll let you go after this, I teach employment discrimination. There was someone that was just awarded a $100 million claim. Most of it was punitive damages, obviously. It was extreme, but the point is, if I had a case that large pending, I would pay a hacker to put a virus in my system and get rid of those emails. Like, think about what companies would do that. I know, that's the whole point. That's why we need the rule. Please email me your questions for tomorrow. Run out of time.